Okay, let's switch gears let's talk about the process, the mechanics, the nuts and bolts. Uh, with the probate process, I think high level we have these are the legal terms, right? Testate versus intestate, will versus
hmm
no will.
Yep.
Um, and I'm sure that makes a huge difference in how this whole process unfolds, right? But I guess so the core steps that I kind of came up with here that I know is so you're gonna file a petition with the court. The court appoints somebody, the personal representative. You're going to notify the heirs and beneficiaries, you inventory assets, you pay off debts and expenses, you distribute remaining assets, and you close the estate. Now, there's probably a lot we could talk about in each one of those steps,
Yeah.
but if you could just take us through your kind of high level start to finish the probate process.
Yeah, so that was a great explanation of the formal proceeding. The
Okay.
only thing I would switch is you notify the heirs and beneficiaries before anybody's appointed. Um, in the formal probate proceeding, you have to include in your petition to the court. So it's called a petition for probate of will and appointment
Mm.
of personal representative if there's a will. If there's no will, it's called a petition for adjudication of intestacy and appointment of personal representative. So you're either saying, I want the court to read the will or to look at the will that I'm presenting and say, yes, this is valid, or I want the court to say, yep, we're gonna say we're gonna rule that there was no will, and because there was no will, we're gonna say who the heirs are at that point. So it's really more beneficiaries of a will or heirs of an intestate estate.
Okay.
Um, yeah. And that all has to go in the document. So you're already talking to people. People are already going to know, unless you just know everybody's address off the top of your head,
Mm.
but they will all get all the people who are identified in the document will get a copy of the document when you file it, the petition.
Okay.
So when there's a will, let's say you left your assets to two of your children and you were excluding one for whatever reason,
Mm.
you still have to say, these are all of the children of the deceased person.
Mm.
Two of them are beneficiaries of the will, one is not. That one is still going to be notified. So it's not
Mm.
because it gives them an opportunity to say, wait a second, you know, I have
Right.
a will that says I am a beneficiary. So that's
Mm.
where it's got unknown variables and things like that. I mean, the purpose of probate, of the formal probate proceeding, because you are required to give notice to everybody, the purpose is really for the court. The court's not reading the will and saying like, well,
Right.
I know Mrs. Takikawa and this is what she, obviously it's an opportunity for all the people who are being excluded or who are being included. It's for everybody to know what's going on, what's
Mm.
what, to say this is the will from 2018. So that if one of the other kids knows, oh no, I have a will, from when COVID happened, I was with mom and we redid her will. It was 2021.
Mhm.
So does it supersede the 2018? Yes, if it's a whole brand new will and it says that it revokes it. It's all like I'm
Gotcha.
trying to stay high level, but it's like
Yeah,
all of
yeah.
these things are what kind of comes into play. But that's why formal proceedings, there's notice to everyone. So it gives
Mm.
everyone an opportunity to either object or agree. The agreeing part can be helpful for making the process go faster. I mentioned earlier about whether someone has to show up at court or not. If you've got everyone's on board with what the will says, everyone's like, "Yep, that was the plan. Yep, there's nobody else. It's normal. It's the four of us kids. We're all sharing equally." If they'll all sign documents that say they're on board, then that's part of what lets the court know there's no fight here, there's no issues, we're ready to go. And the court will say, okay, everything looks above board here. We don't need to actually have everybody show up. We'll just grant this on the date of the hearing. So part of it too is because in a formal proceeding, notice, and we're talking about notice to people, you have to file notice in the newspaper to say if there's any unknown interested person. So if there's anybody who wasn't included in the petition, these are the children from other relationships or prior relationships who weren't identified, something like that, who would come forward. It's not always that. Sometimes those notices are important when there are no children and we're dealing with,
Mm.
we just got to find like cousins or whoever
Right,
might be
right.
related to this person because they weren't married and they didn't have kids and they died when they were 70. So we got lots of people, that we might need to
Mm.
contact. And we don't, one side of the family, you don't know the other side, the mom's, I'm dealing with the cousin on the mom's side, but we got to deal with the beneficiaries on the dad's side. So, or the heirs on the dad's side. So the notice in the newspaper becomes important to sort of find those people that you may not know of. And then also creditors, which I think we'll talk about later. But
Okay.
all of that goes into the notice part of
Right.
what you laid out earlier. The hearing happens, the hearing is usually 2 to 3 months out from when you file the document. In First Circuit, the neighbor islands are all different. All the islands are different. All the circuits are different for how long it takes before you get a hearing date. But because of those notice requirements, it's at least 30 days out. So it's usually 2 months, 3 months out. Um, and on the hearing day, if you do have to have the hearing, you go in, the attorneys go in, the judge asks for questions. Usually the judge is looking at, was everybody given notice? Because once you also have to prove that you gave notice to everyone, so you can't just say, oh yeah, I mailed this thing. And you need to have like a certified mail with a return receipt to know that the person got it.
Mm.
Because sometimes your addresses are wrong. Sometimes, people don't check certified mail. So you have to
Yeah.
like make attempts to make sure that the people are actually getting notice of what you're doing. Um, and once let's say the hearing happens, any questions or issues are sorted out. We've got the person we asked to have appointed as personal representative is appointed. Great. Yes, that opens the door to start the process. When you have a formal hearing, I just like to give people even like the timeline again. Once you have that hearing, you don't get that document that day,
Mm.
from the court. Everyone else that had a hearing that day, everyone submits their documents to the court. Speaking as a former clerk who went
Right.
through all these paperworks, you got to give them time to then receive your order that you submit that says, we're appointing Stacy as the personal representative. They have to make sure everything matches. They have to make sure if there was anything the judge asked you to do at the hearing before they would grant the petition, you have to make sure people did that. So it's a
Mm.
process that can take another 2 to 3 weeks before you get the actual document you need to go to a bank to
Mm.
sign a deed, for property. And then, yeah, so like you said, then they have to figure out, the person represented has to figure out what are the assets we're dealing with. We know about the house. Is there anything else? Because once you are appointed as the personal representative, you're a fiduciary with there are many, many laws on the books about what you're required to do, what you're not allowed to do,
Mhm.
how you have to behave, how you have to communicate. It can be bigger than you expected because you really do. You have to make sure their taxes are filed. You have to make sure any final expenses are paid. You have to deal with debts. You have to identify debts if you can. You have to find creditors, notify creditors, et cetera, et cetera, et
Right,
cetera.
right,
So yeah, assets, debts, and then you have to tell all the people. You have to
right.
inform all those heirs or beneficiaries. Here's where we started. Here's how much I had to pay out for the attorney. Here's how much I had to pay out for the debts. Here's how much I took as my fee, and now here's what everybody else is going to get. You can do that informally without having the court approve of what you've done. And so for family situations, again, when there's no fighting or anything, you can just sort of make sure everybody's okay, sign
Mm.
something that says, I'm not going to sue my brother later. I appreciate what he did and I approve of it, no questions. Then they get their check and everyone goes their way. Or the personal representative can submit their spreadsheets to the court saying, here's what I did. Can you please approve it so that I'm not going to be held liable later? And again, there's
Mm.
notice issues there. There's a certain format you have to follow for your accounting. But then you can get approval from the court, and the court can discharge you and say, okay, you're done. Thank you so much. And then sometimes that will happen, and a year later, the person will say, "Oh, we got another check, or
Mm.
we got a statement or a mailing from somebody about some annuity we didn't know that the person had." If you formally close the probate, then you have to open it up again. So you have to go
Okay.
back to court and say, "Oh, there's something else we discovered." Or if it's a mainland asset, you have to either reopen the probate in Hawaii to then do the piggyback proceeding in that other state, or at that point you can just do a probate in that other state if you've already closed Hawaii. So it gets complicated the more complicated someone's assets are, but
Mhm.
that's the general start to finish in the formal. The
Okay.
informal process we've talked about is the simpler one. It's meant to be quick and simple for quick and simple estates. Um, I've had, the one I just submitted was mom and dad, daughter and husband are tenants in common on a property on Kauai. The mom passed away in 2021. They thought they were all joint tenants. And come to find out, I think they're trying to refinance or something. And oh, nope, you're all tenants in common. So we have to do probate for the mom's estate.
Mm.
Um, didn't have a will, married, two children. So there is another sibling other than the daughter who's on title. But uh, the dad, the on title, he's going to be as the surviving spouse, and the only children involved are children of their marriage. We can do an informal probate where I'm just submitting, and in that case, an informal, it's called an application for probate of will rather than a petition, or an application for appointment of personal representative without a will.
Mm.
So you don't have that adjudication word in there like you do for the petition, because adjudication implies the court and the judge were involved. So
Mhm.
informal, you submit to the court registrar. It's still a court employee, and they have experience and credentials, but they just review the paperwork you submit, and they're going off of what you're telling them. So the application has to be signed before a notary, just so that we can say that the registrar can be like, okay, well, at least I know it was Stacy Takekawa who signed this document.
Mhm.
But if I say there's only two siblings, and there's a third one I'm leaving out on purpose because I'm the bad actor, the registrar is just going to say, well, I can approve what you've sent me based on what you sent me. If that other sibling comes forward later and says, wait a second, I was left out, everything I've done is not, oh, but I was court appointed, so I'm covered. No, it's you lied.
Mm.
You're not off the hook for that. It's so it doesn't work again when it's anything complicated or weird, you still have the court, or you don't have the protection of the court when you're doing it informal if you're not being truthful. But if everything's on the up and up, and you're just like, yep, in my case with my family that I just had to submit for, we should have those documents back within a week of submitting to say, here's the letter, the document that is issued that says, Stacy has authority to act. So in this case, the husband's going to have, or the dad's going to have authority to act and sign the paperwork to take his wife's interests, give it over to him. And then he and his daughter and his daughter's husband can sort out the titling now and the refinancing and all of that. And all of that will have happened within, like I said, a week versus months and months and months.
Gotcha. One question that came to my mind was, let's say there is no will, and the court needs to appoint a personal representative. Do they just does one of the siblings just kind of nominate themselves, or how do they go about deciding who that person will be?
Yeah, so the law gives a list of priority who gets to be appointed.
Mm-hmm.
It starts and they don't differentiate between will or no will. The law says if there, the person who's nominated in a will is first. So if there's no will, then we go to, I should look at it before I lie, but it's, spouse first, and then this is like embarrassing
No,
that I
no,
don't
that's
know
okay.
it
So
off the
there is
top of
there
my
is an
head.
actual there's like a document. It's not just somebody can
It's
just come forward and say I'll do it, and then they say okay, that works. Or
Yeah, so that's usually how, if you don't have a will and you're in the informal process, that's what your document is going to say. So in this case, because the case I just mentioned, because we have the husband, he has
Mhm.
priority over his children to be appointed. So no issues there. Let's say the husband was also gone. Let's say we're dealing with just children, like you were saying, siblings. Um, there is no priority among them. They are all the same. And so that's why if you're trying to do the informal process in that case, and there's two siblings that have equal priority because they're at the same level to serve, if the registrar doesn't know what the other person's position is, they may require that we get a joinder or a renunciation or something from that other person that says, I have the same priority as Stacy. I'm fine with you appointing her. Great. No questions asked. The registrar will let that through. Because I kind of skipped over it, but in the informal proceeding where I was talking about for formal, there's all these notice requirements. For informal, there are no notice requirements, with an exception that I won't go into. When it's somebody who's not related is trying to get appointed, the registrar requires notice ahead of time, but we'll go to still simple situations.
Right.
Um, Siblings, you would just say, if in order for to do it informally, you would want everyone on the same page with who's getting appointed and signing off and showing the registrar through a signed document filed with the court that they're all on board with, Stacy being appointed
Mhm.
versus the other siblings.
Okay. And so it sounds like timeline. There wouldn't be there's no like timeline that you could give for informal or formal because each situation is so different, right? But I
Yeah.
but I guess if we say it's informal, best case scenario, I'm just wondering what's the fastest speed that could, you could go from start to finish.
Yeah. Well, if they fastest speed would be there's one person. So I have a another situation where there's an only child. Um, his mom passed away already, so now his dad has passed away. Mom and dad were entitled to a house here in Kaneohe,
Mhm.
and the son is like, I just need, to get appointed so I can transfer the deed over to myself. No problem. Sign the paperwork. Well, death certificate is the only waiting period. We have a
Mhm.
death certificate for both mom and dad. Once you have that, he's in my office, he's signing the document. I file it that day, especially because it's First Circuit. I submit the paperwork to the court within, like I said, within a week. I mean, it can take longer if they're
Oh.
inundated, but
Mhm.
there was a time where it was the next day it would go. There are
Wow.
sometimes still where it's 2 days later, the registrar will approve it and issue the paperwork you need. He can come back to my office. I can sign the deed, the next day. We
Mhm.
can record it. It's done. You could do it in a week.
Wow.
That is unique, and you wouldn't really go that
Right.
fast for other reasons. But in that situation where there's one kid, one thing,
Mhm.
maybe it's been some time since the parents have passed, so we're not worried about creditors at this point.
Mhm.
Stuff like that, it really can be fast.
Mhm.
But that's a
Yeah.
unique situation.
Right. And I'm sure on the opposite end, there's probably instances when it drags on and on and on.
Yeah, and so I should mention once the court issue, either the court or the registrar, when she gets the document that says Stacy is appointed the personal representative, those are good for 3 years. They're valid for three
Mm.
years from that date. You can ask to have it extended. On the neighbor islands, at least on the Big Island, there's a process where you can ask for that extension informally, again, where you're asking the registrar. First Circuit doesn't have that, and once you're asking for an extension, that moves into a judge is getting involved. Doesn't mean there needs to be a hearing. There are ways to do it without having a hearing, but that requires all the interested people to sign off and give their approval for the request.
Okay.
But yeah, there are ones where, and then so let's say the document I'm talking about that you get, it's called letters. You get, and so people, I do also get the question where someone has passed and the kid is dealing with the assets and they say, oh, well, the bank is asking me for letters. Is that something that you can just sign and give to me? And I'm like, oh, no, that's a probate thing.
Mm.
So letters testamentary is what you get when there's a will. Letters of administration is what you get when there's no will. And it's not like letters like pages of something
Right.
that says dear sir, madam, whatever. It's just that what you call the court document that appoints you, that shows your authority as personal representative.
Mm.
Um, so the letters can be the first time you get it, it's just letters. Once you ask to renew it, you've got first amended letters. Next one, you've got second amended letters. So every time you renew it, you're kind of showing the extension of time. And I can't remember if there was anything. I do remember doing 6 letters once as a clerk. I
Wow.
saw a 6 amended letter. There are probably ones that have gone longer.
Hmm.
But you just have to keep because sometimes in one of my other cases I'm working on, we're waiting on something happening in New York.
Mm.
The person owned part of a parking lot in New York that they're trying to sell, a parking lot. But I
Okay.
imagine in New York, that's
Sure.
probably pretty valuable.
Yeah.
Um, and they couldn't find a buyer, they're working on all of that over there. And once that's sold, there's a portion that's coming to somebody who has passed away in Hawaii. So we're just waiting on New York. And in the meantime, we're just kind of keeping the person here appointed and ready to go for whenever that distribution comes in. So different reasons like that to get the extensions.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Katita and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by ToBA Financial. For Jason Katita, investment advisory services are offered through ToBA Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.